Yeah, thanks. Well, thank you very much for that introduction, and thank you very much for inviting me to speak with you, members of the board, and everyone else present. We really appreciate that, and hopefully, I'll be able to provide some information about the operations of our bail court here in Kingston. Just before I do, I would like to say we're extremely fortunate here in Kingston to have a great working relationship with the Kingston Police. I see a number of inspectors in the back here too, which we have a terrific working relationship on issues, which greatly assists not only in bails but elsewhere to ensure bail courts are running efficiently and that there is a view to ensuring public safety is paramount. So I did want to say that because Kingston Police has been very diligent, and we appreciate those efforts. So with that in mind, I'll turn to the next slide there, and start kind of with some of the general operating principles of bail. Um, Obviously, an accused person, when they're charged with a criminal offense, they can be released by the officer conducting the arrest. That can be done by various ways, including release on an undertaking. But many times, as a result of risk to the protection of the public, risk of reoffense, or risk of failing to attend court, the police feel that it's a higher either release conditions or detention is required. And so they'll bring them obviously to bail court, which this presentation focuses on. They need to be brought within 24 hours of the arrest, and our bail courts are operating 5 days a week as well as on weekends to ensure that the accused persons are brought within the mandated 24 hours. As you can see from this slide, one of the founding kind of and guiding principles in bail court in our criminal justice system, which comes as no surprise, is the presumption of innocence. And that's a big principle because it flows then into another presumption mandated by the criminal code as well as case law, which is that accused persons, because of the presumption of innocence, are presumed to be released without conditions unless the Crown can justify and show why either a release with conditions is required, a release with surety is required, or ultimately detention in custody is required to achieve public safety or attendance in court. And so it's that those presumptions then flow into the further charter rights that the accused have in this case, which is the right to reasonable bail. They have the right to reasonable bail in the sense of being released from custody, but also the right to reasonable bail in terms of what conditions are imposed on them. So that kind of sets the tone for then the rest of the presentation and why and how bail courts do operate in the manner that they do. I'm not going to be able to hit everything on these slides. I understand the slide deck's been provided to members of the board, so I'll skip now to slide number 3. Um, can we just go back one? Yeah, thanks. Just finishing off on some of the general principles. At the end of the day, it's obviously always up to the justice of the peace who's presiding in bail court, whether a person gets released or not. It is always their ultimate decision. As I said, we have bail courts operating every day of the week, and we have dedicated bail vetters working closely with Kingston Police every morning, receiving briefs for the new arrests that come in each and every day, reviewing those briefs with a view to determining via the principles we'll get into shortly, whether or not persons can be safely released into the community with conditions, or we need to seek detention and have what's called a show cause hearing, a bail hearing, where we lead evidence and ultimately a justice of the peace determines whether the person can be released or not. If we can move then on to slide 4, please. Thanks very much. I would just note that recently, or somewhat recently in 2019, there were a number of amendments to the criminal code on bail that are important. They didn't necessarily change anything that in terms of the guiding principles, but they re-emphasized what the Supreme Court of Canada has been saying since 2017 in a very important decision called Antic, that there is what's referred to as the ladder principle. and that the Crown ultimately has to show and justify why a person cannot be released without condition. And moving up the ladder, why they can't be released with minimal conditions or why they can't be released with conditions and a surety. Again, moving all the way up to show and justify at each level why this type of release cannot work in terms of safety of the public or ensuring attendance at court. And if the Crown can justify that, then potentially a detention order ensues. But Antic really focused that latter principle, which we'll talk about again in a moment, and ultimately had a significant impact on the operations and results in our bail court. And it was ultimately codified in these 2019 amendments. We can go on to slide number 5, please. Some further reform, bail reform that's worthy of note here for members of the board was in 2023, which came as a result of some very tragic consequences to a police officer in southwestern Ontario, which I know we all are aware of. And as a result of that severely tragic consequence, some reform was conducted to the criminal code. And what's called reverse onus provisions, which previously existed in the criminal code, were expanded. Those were largely reforms in 2023. As I said earlier, generally the presumption is that the Crown must justify and show cause why a person can be released with conditions or needs to be detained. There are certain charges when the accused is charged with certain classes of offenses where it's switched and the reverse is true, and the accused must actually show and justify to the justice of the peace why they can be released, which is a significant difference and a very different operating principle. So in these reverse onus conditions, they were significantly expanded in 2023 to include a lot of firearms offenses, also expanding on intimate partner violent offenses. So now where someone is charged with an intimate partner violent offense and has been previously convicted on their record of a prior intimate partner violence, it's presumed to be a reverse onus situation. And there's some other changes as well, including those that were charged with violent offenses with use of a weapon, where again they have a similar conviction on the record for the same within 5 years. Again, reverse onus provisions apply. Those are some of the highlights that were added to already reverse onus offenses that already exist in the criminal code. And obviously, in that case, the latter principle doesn't apply because it's presumed they are to be detained unless they can show cause why they can be released. So those were important amendments. So this slide 6, speaks to the latter principle that I've been referencing already here. And again, is applies to the situation where, generally speaking, the Crown must show cause why conditions are required or why ultimately detention is required. And the graphic really is just supposed to demonstrate the thought process that Crowns have to go through, and ultimately, no matter what is being recommended by the Crown or defense to the court, the justice of the peace has to ultimately analyze for their own, going through and up this ladder. Again, presumption being the accused is released with no conditions. And so what is it in this particular case that requires other conditions, requires a financial promise to pay, requires a surety as well. Obviously, a surety being someone that can supervise and monitor the accused in the community. And certainly sureties were previously, prior to Antic, used, I would think, much more significantly. And post Antic, again, because of the principles enunciated in the case, the court indicated a surety type of release is at the top of this ladder and is a release that can only be done when the Crown shows that it truly is necessary. And so it's this latter principle that the Crown and the court ultimately have to engage in each and every release or detention being sought. We can go then to the This slide just really speaks to the reverse onus provisions in total. I previously told you about the amendments and the expansion of it. This just outlines all the reverse onus provisions. A big one to highlight for you is breaches of release order. That is by default. If someone is charged with breaching their bail condition, they uh, obviously get arrested and generally speaking come back to court. And if they're charged with breach of a release order, that is a reverse provision where again instead of the Crown having to justify why they ought to be detained or released with certain conditions, they themselves have to show why they can be released safely into the public. There are a number of other ones that some of which I've already spoken to, including some drug provisions where it's presumptive reverse onus. But a big one on top of the ones I've already mentioned is the breach of release order. Just briefly on this slide, which just references what's called 469 offenses, which are some of the most serious offenses in the criminal code, including murder. And then a lot of, we don't see too much of alarming His Majesty anymore. um, but it's still there. But obviously, for very serious crimes such as murder, it is a reverse onus, but also it does not get dealt with in our bail court. An application has to be made to the High Court, the Superior Court of Justice, before bail can be dealt with. And there's some other obviously serious crimes as well. Can move on to the next slide there, please. This is a very important slide, and arguably I could have put it a bit earlier in the slide deck, because ultimately what this slide shows is the basis for which the Crown can either seek detention or seek release with conditions. Everything the Crown does in terms of seeking release with conditions or detention has to revolve around the basis for which we're doing it, which are these three potential grounds. It can be one, two, or all three. But the first ground, as you can see, relates to what's called the primary ground, which is there a risk for the accused attending court? Is there a risk of absconding? That is a ground where the Crown can seek release with conditions if justified, or ultimately seek detention. A very common ground, the secondary ground, relates to ensuring the protection of the public or the victim, specifically in the prevention of further commissions of crimes while on release. Again, and that's a very common one for the Crown to base its decisions to seek conditions on release. For example, no weapons, no contact with particular victims, to stay away a certain radius from geographical locations. In some more rare instances now, a prohibition on the use of alcohol, if that was a contributing factor to the crime. Prohibition on the use of the internet with certain exceptions if it's a case that involves digital crime. There's numerous conditions that can be imposed, or ultimately, if the Crown determines that even the highest rung of the ladder, release with surety with stringent conditions, including house arrest, or even in some instances, GPS monitoring isn't going to be sufficient, the Crown will then seek detention. But it all has to be based on one of these three grounds, either the risk of attendance in court, the risk to the public, the safety of the public or the victim, or the third ground, which is maintaining the confidence in the administration of justice, which effectively is that would this release impact and decrease the confidence in the administration of justice. So those are the three grounds that ultimately the Crown makes its determination on, no matter, ultimately if it's the Crown onus where the Crown has to justify it, and even where the accused has to justify it. It's all based on these three grounds. And so again, and we've talked about this, the Supreme Court of Canada very recently has indicated when the court is considering release, or even when the Crown is considering release, that the conditions have to be clearly articulated. They have to be minimal in the sense of only what is actually necessary to achieve either public safety issues, if that's a concern, attendance in court, if that's the concern. they have to be reasonable in the sense that they're able to actually be followed and tailored to the risk that's before the court. And sometimes that can be difficult to achieve. Um, and as I've said, they've got to be linked to the risk, whether it's the risk of failure to attend court or protection of the public. So this case, Zora, has been a significant case, which has had real impact in terms of what types of conditions that we're seeing and what conditions we've previously seen historically and what conditions we're seeing now. It's had a significant impact on that. So I don't want to, looking at the time here, I know I don't want to keep you guys longer than I need to. So I'll move quickly to the next slide. This just indicates the Crown Prosecution Manual is a very helpful directive for Crowns across the province, which provides all Crowns guidance in bail court, but effectively directs us as prosecutors to seek detention where we believe that the release of the accused would jeopardize the security or safety of the public generally or the victim specifically. That's our operating guideline and our focus, unless, of course, the release conditions can mitigate the risk. And so that is what we set out to achieve. And if we can go then to the next slide, this just provides a bit more details of the Crown Policy Manual, which I'll leave for you to review further. And I'll just finish up with slides 13 and 14 so I don't intrude too much on your time. But I think an important thing to note recently in 2023 has been the imposition or implementation, I should say, of the Intensive Serious Violent Crime Bail Team. A bit of a mouthful to say, but it's had, in my view, a significant positive impact across the province, but also in Kingston. We have two Crowns that are part of a dedicated this serious violent crime bail team, where the objective is to flag at an early stage high risk offenders by the nature of their crime being a serious violent crime, but also by way of their past for those that have significant record for violence in their past. And the idea this program, and including the Crowns in our office that are dedicated to it, are trying to flag these at an early stage to make sure that Crowns that are doing the bail hearings, including these experienced Crowns themselves, are have adequate and proper time to prepare for them, that the materials that the Justice of the Peace needs to make an appropriate decision have been gathered and are properly prepared and before the court, and that any deficiencies in the case are spotted at an early stage so they can be approved upon. So that's been a new implementation that I think has been working well. And um, as we move on to slide 14, there's some other more provincially wide initiatives that have been taken on. As I said, we here locally have a dedicated Crown Bail Vetter, and we also have the Bail Verification and Supervision Program, which assists accused that don't necessarily have the ability to have a surety, but can be safely released in the community with the help of, in this case, John Howard Society that runs the bail verification program. So, and helps them provide counseling while on release or residence upon release. So that concludes my presentation. Hopefully somewhat informative. I'm happy to answer any kind of general questions, but I also am cognizant of the time and just really want to say I very much appreciate being invited here.
Thank you very much. Any of the board have any questions? Christian? Yeah.
No. If you're offering chair. So you make the system sound like it works like clockwork and it works just fine. And my sense is that many members of our community, including myself, including downtown business owners, would tell you that the system is not working fine. We have data from Vancouver of a single person having been rearrested 4,000 times. The system is failing Canadians as far as I can tell. Yet you're presenting it as runs just fine. We can see provincial attempts to try to make a broken system work better for the public. And the presentation was titled as how bail is administered in Ontario. And so I'm just interested in, respecting that as a member of the profession and as a Crown, there's only so much you can say to assure the independence of justice, how we explain the difference between what you just presented to us and at least some members of the public in their perception of the system.
I guess to start, I would say this presentation wasn't designed to present the bail court in a positive or negative fashion. It was really designed to be informational, as in these are the guiding principles, because I certainly respect and appreciate that there are those, it sounds like including yourself, that don't necessarily share some positive views with respect to the operations and or the kind of consequences that are occurring in bail court. That's difficult for me to really speak to. I can't really speak to that. So I apologize because, I mean, one, there's just so many variables and factors that really go into that. We could be here for quite some time. And it's not that I don't necessarily want to get into that discussion. I'm just not sure I'm the appropriate person to engage in that discussion, but I don't disagree that it's a discussion worthy of having. And I certainly want to make clear that I wasn't attempting, if I did, that was not necessarily the intent to suggest that it's all working like clockwork and everyone should be happy or mad with it. It was more to just provide that informational component because, ultimately the public will have their own views as to how it's operating. But I certainly can say this, that there's a number of persons in the criminal justice system, the police included, that are making significant efforts to do their best to operate within the legal framework that we have to keep people as safe as possible. I can certainly say that, and there's, as I say, significant efforts on Kingston Police and the Crown Attorney's Office to ensure that everyone, that the safety of the public remains paramount in the context of the legal framework that we have. So I'm sorry, I know that probably doesn't answer the question to the best that you'd like, but that's probably the best that I can offer here.
And I just want to acknowledge that I respect the fact that, in a democracy, you can only work within the tools that you've been given, and that often you find yourself in very challenging situations of trying to balance different priorities and imperatives and on different cases.
Thank you, Mr. Chair. Andrew, thank you for coming. Really interesting information. I do have a couple of just straight questions just to understand the system better. You mentioned that, for example, that one condition that can sometimes be applied to bail is a prohibition of alcohol if alcohol was a contributing factor to an offense. Is that also an option for other substances, like other drugs or other issues that could be a contributing factor in an offense? Is that also an option?
Yes. So the criminal code lists certain conditions that can be imposed, but there's also a basket clause that just says any condition that's necessary and essentially appropriate. Historically, we used to see, if historically, I think the statistics would likely show where alcohol was used in the offense, it was very routinely imposed historically. However, since the imposition of Antic and Zora, and the principles of restraint that I spoke about, I think we probably the court has indicated that it has to be reasonable and taken into account. For example, someone that's addicted to drugs is imposing a term prohibiting them from using drugs or alcohol if they're addicted, and you know that it's effectively going to set them up to breach. Is that reasonable? It may be designed to the risk. Is there a way to tailor that? In some cases, for example, on the alcohol example, we've seen not to drink alcohol, or not to have alcohol in your system when you're outside of your house, if the risk, if there was an event that occurred outside of the house, and alcohol is related. So those are possibilities. However, I can say as a result of some of the more recent case law, we're seeing less of those conditions, or those conditions tailored, because of obviously um, the concern, I think, of the higher courts that imposing a condition that we all know the person cannot adhere to isn't necessarily appropriate. But each case, there are a number of types of conditions. It really depends on what the risk is. What is the risk? If the risk is protection of the public, and specifically the offense before the court being committed again, any condition that can be crafted to mitigate that risk is potentially available if it's reasonable.
That's interesting. My second question is how you balance presumption of innocence with protecting the public from further offenses. So, I mean, Christian's given an example, and we know there are examples locally where someone is repeatedly arrested and basically as soon as they're granted bail, they go out and commit exactly the same crime over and over again. And I'm just curious to know, like, in making the case for protecting public offenders, does that only come into play if there's been a prior conviction, or is there, if somebody has been rearrested many times with the same offense, would that then be a factor in being put forth in a bail hearing to say perhaps, if they're re-released, they're just going to do it again? So is that something that would come into play?
Absolutely. So, the presumption of innocence obviously flows into a presumption of bail and the right to reasonable bail, but the Crown also takes into account, one, the strength of the Crown's case at its early stage. It's sometimes hard to know what the strength of the Crown's case is early on, but that's certainly a factor that the Crown's must take and the court must take into account in determining secondary ground concerns or risks to the public moving forward. But certainly as well, outstanding charges. If someone has numerous outstanding charges and continually is arrested with new allegations, likely there's a breach charge involved there, which then turns it into a reverse onus provision, and the accused person must then justify why they are to be released, and that will absolutely factor into the Crown's position. And as we all know, it's ultimately the just of the peace's determination, and it may or may not be a situation where the Crown reads the new allegation, reviews the new allegations, and takes a position that detention is warranted as a result, or it may be that a higher step up the ladder with a better surety or GPS monitoring may mitigate that risk, and the Crown agrees to a release with higher provisions and conditions than previous. It will all depend on the case, but at the end of the day, it is the just the peace's decision, and they're basing it based on the framework outlined by them or to them by the Supreme Court of Canada and the Criminal Code.
Thank you.
I just want to say thank you. And oftentimes, Andrew or his colleagues can be found at the court battling on our behalf to hold people in custody. And as he said, the JP has the ultimate decision, and sometimes it works and sometimes it doesn't. But we appreciate all the effort that goes into it. And we know we can pick up the phone and give an advance notice and all that. And that's the big part. And we all have our spots in the judicial system. And sometimes the decisions we all want to make aren't what are made, but you know what? We just keep moving forward, and we appreciate everything you do for us on that. So thank you.
Thanks, Chief. Really appreciate that.
Andrew, we really appreciate you coming by today, and thank you very much.
The pleasure's all mine. I'll excuse myself if that's all right.
Yes.
Thank you.
Okay, so then we'll have there a disclosure of conflict of interest? No? Can I get an approval of the agenda? Thank you, Christian. Gail, all in favor? Thank you. And adoption of the minutes from meeting 2409 held September 19th, 2024 be adopted. Christian, Brian, all in favor? Thank you. Is there any question, or first of all, we'll get a motion to accept the communications from The Office of the Inspector General of Policing, Canadian Association of Police Governance, Ontario Services Board, Hereditary Crane Clan Chief of the Chippewa Nation, and the Ministry of the Attorney General be received. Thank you, Chris. Ryan, all in favor? Thank you. Is there any questions to any of these applications? No? Okay. Then information report. Ask that we have a motion to accept that. Gail, all in favor? Thank you. Following reports. I'm going to ask Chief Fraser. Talk to the statistics.
Certainly, it's, we have the report, you have the report in front of you, which outlines a number of different offenses. And just based on the presentation we had, I wanted to just drill down into a couple of our kind of overarching columns that we have. And just where we talked about breach of probation and breach of release conditions and the reverse onus and things like that. Q2 for breach of probation, we had 90 incidents, and in Q2 for breach of release conditions, we had 70 incidents. And, we were looking going, sometimes I think maybe some of that enforcement angle was being missed. So we came up with some guidance for our patrol officers, for our staff, and our senior officer team got together. And we just wanted to really look into this. And I can tell you in Q3, breach of probation, we went from 90 to 200. And breach of release conditions, we went from 70 to 168. And, obviously the time of year, we went from into the summer, and we're dealing with the summer, and then a number of different things that occurred over Q2 and then in Q3. So, obviously there's a lot going on, and I just really highlighted those offenses because I think it's timely. There's a lot going on. Quarter to quarter, you just never know, but sometimes they all have a significant impact, and that's just one. And obviously having that in a reverse onus atmosphere allows people they have to go and justify why they should be released again, which is a lot easier sometimes than proving the substantive offense. So, and generally a lot of the people we arrest, they are already on conditions. So I just thought I'd highlight that. There's other things here that obviously, quarter to quarter, we have fluctuations, how things go up, how things go down. And we also have our use of force kind of incidents as well. And we always report to those a couple times a year plus then at the end of the total numbers. So it's tough when you look at incidents on a quarter to quarter because there's just things like the weather that change things, but I'm happy to try and answer anything, but certainly the breaches have really exploded, for lack of a better term.
Questions to the chief? Go ahead, Christian.
I just want to thank you for keeping track of the data because it's onerous. It imposes yet another cost on the organization, trying to track all this, but it allows us to have a bit more informed and evidence-based conversation, community, and hopefully, like on many other challenges, we've developed endogenous, maybe not solutions, but at least approaches and responses to some of the challenges that we face.
And I think just to kind of piggyback on that, if we look at where in late May, we expanded our downtown beat officer program to work with the city and the DBIA as we partnered. The officer down there has done 167 hours on foot, 61 hours on his bike, 77 hours in a vehicle, for a total of 305 hours, and on his own, along with another member, between the two of them being beat officers, affected 32 arrests. Many of those arrests are attributed here, and I know the next quarter will probably even be more significant as we see some of the issues that have been going downtown. So there's a correlation of where it's happening and how it's happening, and continue to track all that. But once again, working with our court system, we can only do so much. But we're going to do our part. And I always tell our officers that's where our job ends. And, 33 years ago when I started, I remember my field trainer saying, don't go to court and don't watch the end result or you'll quit being a police officer. And so I took heed on that because our job and convictions are two separate things. Our job is to bring the evidence to the court, and then it's the court's role there. And, as much as it can be frustrating and things like that, I've seen the pendulum go. So it goes one way, it goes another way. And oftentimes our crowns are infighting on our behalf to try and have people held in custody only to see them get released. And then we know we just need to ensure that if they're breaking the law again, that they're brought to justice. So I applaud everybody for that.
Gail, go ahead.
Chief, just hearkening back for a moment to your breach numbers that you were giving us. Were there any, you mentioned that there were weather and lots of other factors play into this, but were there any changes in law, policy, or process that may have actually contributed to that increase in numbers?
I think certainly from our perspective, sometimes there's that helpless feeling where there's, hey, after it's like fatigue, where officers are getting fatigued and they're going, okay, we've done this 3 times this week already. So you let the 4th time go. And we've just been, as a senior officer team, encouraging people, if it happens 3 times and then on the 4th time, keep going. And our senior officer team, we're even going out and doing it ourselves. Because it is important, and if the offenses are there, we need to follow up with them. And I think sometimes it just gets into that the generalization, because the public are mad at us because they're like, this person broke into my place 3 times. Why are you doing nothing? And it's like, no, the system is designed this way, and we'll bring them to justice again, and they may get released. But hopefully, there's conditions that prevent them from doing it. But if they do commit again, we'll be there to make the arrest. So I think it's just working with our staff and continually reinforcing that, no, this is our job, and the courts have a separate job, but our job is this. So let's do that and continue to do our job and do it well.
Foreshadowing what's to come. I'm guessing, like last year, you're going to use the even better numbers that we have this year to work it into the budgeting process so that the public understands the cost of recidivism and reoffending that we're absorbing with municipal tax dollars.
Yeah, certainly at the end of this year, we'll be able to attribute it. We have a formula on what it costs for a breach, just a simple breach. I know we have that, and we'll attribute that to those numbers at the end of the year, so we can bring it to the board and say, here's just what that offense alone cost the taxpayer. And it's a moving target, but like I say, we just don't let our guard down and just keep enforcing. That's what the public demands.
Very good. Thank you, Chief. Next order of business is going to be a certificate of appointment for a new hire. Can I have a motion that for the Kingston Police Service Board issue a certificate of appointment to experienced officer Landon Lackey Ruwald to the Kingston Police effective October 15th, 2024. Thank you, Gail. Thank you, Christian. All in favor? Very good. And then I'm going to ask Board Member Patterson to explain the board size.
Thank you, Mr. Chair. I guess just a quick update that at our last council meeting that we did pass the motion that I mentioned at last meeting. So we will be moving to a 7-member board.
And that's 3 people from City Council, including yourself, a member of the community, and 3 Ontario provincial appointees. Right. Very good. Okay. You have enough seats? Good. Yeah. Okay.
Effective January 1st of 2025.
Okay. Thank you, Laurie. Next, we're going to, I'm going to ask to move in camera. That's all we have for today. Okay. And following matters. Information, that's Section 8 of the Municipal Freedom of Information and Protection of Privacy Act would authorize a refusal to disclosure if it were contained in a record. We'll take a 5-minute break. Thank you.